Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, my name is Salma Alisha Sahdiya, with NPM 234120046, from Accounting Class 23A, Course Business Law. Here, I will explain the material about understanding law and business law. Legal definition. Law is a set of rules created by an authorized institution and is binding and carries sanctions for violators. These rules serve to regulate human behavior in society to create order, justice, and certainty. Law encompasses norms, rules, and principles that apply to various areas of life, such as social, political, economic, and business. Characteristics of law. Law has the following characteristics. 1. Regulatory, provides guidelines for action. 2. Coercive, has sanctions for anyone who violates them. 3. Binding, applies to all people within a specific jurisdiction. 4. General, intended for all citizens without discrimination. 5. Aims to create order. Law maintains harmony in life. Differences between law, norms, and ethics. Norms, unwritten rules based on social customs. Ethics, moral codes and standards of good and bad behavior. Law, formal, written, sanctioned, and enforced rules. Purpose and function of law. The fundamental purpose of law is to create order, justice, and certainty in society. Laws are created to ensure that every individual understands their rights and obligations so that social interactions can proceed harmoniously without conflict. In addition to creating order, law also aims to protect human rights, including personal, economic, and social rights, so that they are not harmed by the actions of others. The function of law in society is not only as a tool for controlling behavior, social control, but also as a means of social change, social engineering, that encourages the development and progress of society. Law functions to resolve disputes through fair and structured mechanisms, both through the courts and non-litigation channels. Furthermore, law is an important instrument for maintaining national stability, supporting economic activity, and creating a sense of security for citizens in their daily activities. Types of law. 1. Law based on its source. Written law, constitution, laws, government regulations, regional regulations. Unwritten law, customs, traditions. 2. Law based on its content. Private law, civil, regulates relationships between individuals, such as contracts. Public law, regulates relationships between individuals and the state, such as criminal and constitutional law. 3. Law based on its function. Material law, contains norms/rules, what is permitted and what is not permitted. Formal law, regulates the law enforcement process, how to file a lawsuit, the trial process. 4. Law based on its territory of applicability. National law, applies within a country. International law, applies between countries. Sources of law. 1. Law. An official source issued by a state's lawmaking institution. 2. Customary law. An action performed repeatedly and thus recognized as a rule. 3. Jurisprudence. Previous judicial decisions that serve as guidelines for other judges. 4. Treaty. An international agreement binding on member states. 5. Doctrine. The thoughts of legal experts that serve as a reference in formulating rules. Understanding business law. Business law is a set of legal rules that govern trade, business activities, and relationships between business actors, both individuals and corporations. Business law ensures that all economic activities run orderly, safely, and with legal certainty. The role of business law. 1. Protecting business actors from the risk of loss or fraud. 2. Maintaining fairness in business competition. 3. Creating protection for consumers. 4. Providing legal certainty for investors and companies. 5. Regulating business dispute resolution mechanisms. Scope of business law. 1. Corporate law. Covers the establishment, management, acquisition, merger, and dissolution of business entities such as PTs, CVs, firms, and cooperatives. 2. Contract or agreement law. Regulates the legal requirements for contracts, types of business contracts, the responsibilities of the parties, and the resolution of defaults. 3. Banking and financing law. Covers credit transactions, accounts, guarantees, digital banking, fintech, leasing, and factoring. 4. Capital market law. Regulates stocks, bonds, securities trading, and investor protection. 5. Consumer protection law. Regulates consumer rights, business obligations, and product safety standards. 6. Intellectual property rights, IPR. Covers patents, trademarks, industrial designs, trade secrets, and copyrights. 7. Taxation law. Regulates income tax, VAT, corporate tax, transaction tax, and business tax provisions. 8. Employment law. Regulates employment relationships, wages, employment contracts, and termination of employment. 9. Bankruptcy law. Explains procedures if a company is unable to pay its debts. 10. Competition law. Regulates the prohibition of monopolies, cartels, dumping, and other unfair practices. 11. Technology and e-commerce law. Covers digital transactions, electronic signatures, personal data protection, and cybersecurity. The role of business law in economic growth. 1. Guaranteeing transaction certainty. Every transaction has a legal basis, minimizing the risk of errors. 2. Increasing investor confidence. Investors only want to invest in countries with legal certainty. 3. Protecting consumers and business actors. Preventing fraud, cheating, and conflict. 4. Regulating fair competition. The law prohibits monopolies, cartels, and unethical business practices. 5. Acting as an instrument of economic stability. Good regulations will ensure the safe and efficient flow of the economy. Agreements in business law. 1. Definition of an agreement. An agreement is an agreement between two or more parties that creates a legal relationship to perform an obligation, namely to do something, not to do something, or to provide something. In business law, agreements are the primary basis for all trade and cooperation activities, as they create certainty about the rights and obligations of the parties involved. A valid and clear agreement can prevent future disputes and serve as evidence in the event of a dispute. Agreements are regulated in the Civil Code, CUPR, specifically Articles 1313 to 1338, which explain the definition, requirements for a valid agreement, and general principles of contracts. 2. Requirements for a valid agreement, Article 1320 of the CUPR. For an agreement to be valid and legally enforceable, it must meet the following 4 requirements. 1. Agreement of the parties. All parties must agree voluntarily without coercion, fraud, or error. 2. Capacity of the parties. Parties entering into an agreement must be adults, of sound mind, and possess legal authority. 3. The existence of a specific object. The agreement must clearly state what is being agreed upon, for example, goods, services, or a form of cooperation. 4. Lawful cause. The contents of the agreement must not conflict with law, morality, or public order. If any of these conditions are not met, the agreement may be deemed void or may be rescinded. 3. Types of business agreements. Some forms of agreements commonly used in the business world include: 1. Sales and purchase agreement. Regulates the transaction of goods or services, including price, quality, and delivery. 2. Investment agreement. Includes capital participation, profit sharing, and investor rights. 3. Cooperation agreement, MOU/partnership agreement. Used for cooperation between companies on specific projects. 4. Lease agreement. Regulates the use of assets such as buildings, vehicles, or production equipment. 5. Intellectual property rights license agreement. Regulates the use of copyrights, patents, or trademarks by other parties. 6. Franchise agreement. Regulates the granting of business rights to a specific brand and business system. Disputes in business. A business dispute is a disagreement or conflict that occurs between business actors, between a company and consumers, or between a company and another party due to differing interests in business activities. Disputes arise when one party feels disadvantaged, an agreement is not fulfilled, or there is a violation of rights and obligations stipulated in a contract or legal regulations. Causes of disputes. 1. Default, broken promise. One party fails to fulfill its obligations as stipulated in the agreement, such as failing to deliver goods, making late payments, or providing substandard quality. 2. Breach of contract. Occurs when the terms of the agreement are ignored or violated, either intentionally or unintentionally. 3. Administrative errors or misinterpretations. Differences in understanding the terms of a contract often lead to disputes. 4. Unfair business competition. Actions such as monopolies, cartels, dumping, and abuse of dominant position can trigger disputes between companies. 5. Defective or substandard products. Consumers can sue businesses if their products cause harm or do not meet specifications. 6. Dishonesty and fraud. Falsifying data, manipulating reports, or misleading other parties in business transactions. 7. Intellectual property rights, IPR, violations. For example, the unauthorized use of brands, logos, or designs. Forms of dispute resolution. If a dispute arises during the implementation of an agreement, resolution can be achieved through negotiation, a direct settlement between the parties. Mediation, involving a neutral third party as a mediator. Arbitration, a settlement by an arbitration institution, faster than a court. Litigation, a settlement through formal legal channels. Business law challenges in the digital age. 1. Digital technology changes business models. The emergence of e-commerce, fintech, crypto, and artificial intelligence, AI, has given rise to new regulations. 2. Personal data protection. Businesses are required to maintain the security of consumer data in accordance with the Personal Data Protection Law. 3. Cybercrime. Online fraud, hacking, and data theft must be legally regulated. 4. Business globalization. Cross-border transactions require harmonization of international regulations. Conclusion. Law is a system of rules aimed at creating order, justice, and certainty in society. In the business world, law serves to provide protection for business actors, consumers, and investors so that economic activities run safely and orderly. Business law covers various aspects such as contracts, companies, banking, employment, consumer protection, and dispute resolution. By understanding business law, business actors can avoid risks, comply with regulations, and make more informed decisions. Overall, law is an important foundation for supporting economic growth, maintaining healthy competition, and creating stability in modern business activities. That's all I can say about the material understanding law and business law. Wassalamu alaikum warahmatullahi wabarakatuh.